Welcome to my channel. Let's look at the formation of a contract in the law of contract. So there are certain necessary legal formalities in the formation of a binding contract. The first one is that the agreement is made as a result of an offer and acceptance. This means that one party makes an offer and the other party must accept it unconditionally. For example, if a seller offers to sell a car of $10,000 and the buyer agrees to purchase it at that price, then it means that they've come to an agreement. So the agreement is as a result of an offer and then acceptance. So the seller makes an offer to sell the car at $10,000 and the buyer accepts the offer. Then the agreement contains an element of value known as consideration. Consideration, something of value must be exchanged between parties. So there must be, actually the price is what is usually considered, the price or payment or money. So for example, a company agrees to pay an employee a salary in exchange for their work. So the agreement contains an element of value, which is known as consideration, which is usually a payment or money. Then the parties must intend to create legal intentions. The parties must intend for their agreement to be legally enforceable. For example, a landlord and a tenant sign a lease agreement for an apartment. So they must intend to create legal intentions. Then another one is that the parties must have the legal capacity to enter into a contract. So the parties must have the legal capacity to enter into a contract. For example, they must not be minors or mentally incapacitated. For example, a 17-year-old cannot legally sign a business contract unless permitted by law. Then another way is that the subject matter of the contract must be lawful. The contract must not involve illegal activities. For example, a contract for drug trafficking would not be enforceable in court. There are certain contracts which require certain formalities before they are entertained by courts of law, and such formalities must be followed. Then the contract should be possible to perform. So there must be possibility of performance in order for a contract to be formed. The contract must be capable of being carried out. For example, a contract to build a bridge in an area where construction is legally prohibited would be invalid. Then it must be entered into freely, or there must be genuine consent. So someone should enter into a contract willingly and not forced. Then another point is that the consent of the parties must be genuine and not induced by fraud, duress, mistake, or misrepresentation. So the consent of the parties, in order for the parties to agree, their consent must be genuine and not forced, maybe by fraud or a mistake or misrepresentation. So it should be genuine consent. So those are the legal formalities that are supposed to be followed in order for a binding contract to be formed.